Let's talk about something that's, well, incredibly tough. What happens when a loved one passes away without leaving a will? It's a deeply emotional time, and suddenly you're thrown into a world of legal jargon and financial puzzles. It can feel completely overwhelming.
So when someone dies without a will, the official term is that they've died intestate. This can cause a lot of confusion and, frankly, a lot of stress. You're left asking, who's in charge now? What happens to their home, their savings? But please know, even in all that uncertainty, there is a clear legal path forward. And today, we're going to walk you through it step by step.
And to make sure you're getting the absolute best information, this entire guide has been put together by the experts at My Tax Accountant. They live and breathe this stuff, helping families navigate these complex situations every single day. So you're in very good hands. Okay, let's dive into this.
So, here's our game plan. We'll start with the basics, what exactly are letters of administration, then we'll look at who can apply, what the process actually involves, and we'll tackle the big one, inheritance tax. After that, we'll cover your duties as an administrator, and finally, run through some common pitfalls to help you avoid them.
First things first, let's get our heads around the most important document in this whole process. Honestly, once you understand this, everything else starts to make a lot more sense.
So, what's our letters of administration? The simplest way to think about it is as the official legal key to the deceased person's estate. It's a document from the Probate Registry that says, yes, you, the administrator, now have the authority. The authority to do what? Well, everything. To access their bank accounts, to sell their property, to pay off their debts, and eventually to share out what's left. Without this piece of paper, the entire estate is essentially frozen. Now, this brings us to something that trips a lot of people up. The difference between a grant of probate and letters of administration. They sound similar, but they're for two totally different situations. A grant of probate is what you get when there is a will. The will names an executor, and that person gets the grant to follow the will's instructions. But what we're talking about today, letters of administration, is for when there is no will. The person in charge is called an administrator, and they don't have a will to follow. They have to follow a strict set of legal rules called the rules of intestacy. Right, that leads us perfectly to the next big question. If there's no will appointing an executor, who on earth gets to apply to be the administrator? Well, it's not a free-for-all. The law is very, very specific about this. Let's take a look. There's a legal pecking order, a hierarchy, and it starts with a closest relative. At the very top of the list is a surviving spouse or civil partner. If there isn't one, the right to apply then moves down to the children of the deceased. No children? Then it goes to the grandchildren. And if that line runs out, the priority moves up to parents, then over to siblings, and then to nieces and nephews and so on.
Now, this next point is absolutely crucial, so stay with me here. There are some important exclusions. Unmarried or common law partners, no matter how many years they were together, have no automatic right to apply. This comes as a massive shock to so many people. The same goes for stepchildren. They are not on this list. It's also good to know that if you have, say, a few siblings who are all equally eligible, up to 4 of you can apply to manage the estate together as joint administrators. Okay, so you've worked out who has the right to apply. Now let's look at the next step. What do you actually have to do to make the application? We'll break it down into a simple step-by-step guide. When you look at it from a high level, the whole journey really has 4 main stages. First, and this is a biggie, you have to get a really accurate valuation of the entire estate. That's everything the person owned minus everything they owed. Second, you have to sort out the inheritance tax forms. You have to do this even if you think there's no tax to pay. Third, you complete the main probate application form, which for this situation is called a PA-1A. And finally, you pull it all together, submit your application, and pay the fee. And now for a little pro tip. There's been a recent update from HMRC that's actually made one part of this whole process a bit simpler, and it's fully in effect as of November 2025. Here's how it works. You used to have to fill out an extra form called an IHT 421. Well, you can forget about that now. Instead, once you've sent your main inheritance tax form, the IHT 400, to HMRC and they've processed it, they will send you a unique code. You cannot make your online probate application without this code. It's a really good change, actually, because it stops people applying for probate before the tax side is sorted, which used to cause all sorts of delays. And what about the costs? Well, as of the 2025/26 tax year, the standard probate application fee is £273. That fee applies to any estate that's worth more than £5,000. If it's under that, there's no fee to pay. So the question on everyone's mind, how long is this all going to take? Well, for a standard, straightforward application, you're typically looking at somewhere between 10 and 16 weeks.
But, and this is a big but, it's so important to be realistic. In recent years, there have been significant backlogs, and some applications have taken up to a year or even more. The best thing you can do? Submit everything as early as you possibly can, and check, double-check, and triple-check that every single piece of information is accurate.
Okay, we've gone through the admin side of things, but now we need to talk about what is often the single biggest hurdle for most families, navigating inheritance tax, or IHT. To really understand this, let's get away from just talking about rules and numbers. Let's use a real-world example. We're going to follow the story of Arthur Williams, a gentleman from Manchester who sadly passed away without a will, and see how his daughter Emily had to handle his estate.
So, the very first thing Emily had to do was that valuation we talked about. She worked out that her dad's house was worth £450,000, he had £75,000 in various savings accounts, and about £28,000 worth of personal items and his car. That all adds up to total assets of £553,000. Then, she had to subtract the money he still owed, about £15,000 in debts, which left a final net estate value of £538,000. This is the figure that HMRC cares about.
Now here's the most important number when it comes to inheritance tax. For the 2025-26 tax year, every person has a tax-free allowance of £325,000. This is called the nil rate band. The first £325,000 of an estate is completely tax-free.
Simple enough, right? But what about any value above that £325,000 threshold? Well, that portion of the estate gets taxed, and it's taxed at a single flat rate of 40%.
Let's apply that to Arthur's estate. We start with the total value of his assets, £553,000. We then subtract the tax-free allowance of £325,000. That leaves a taxable portion of £228,000. So it's this amount that the 40% tax rate will apply to.
So if we do the maths, 40% of £228,000 is a final tax bill of £91,200. And here it is, the biggest challenge for so many people. This tax bill has to be paid before the Probate Registry will give you the letters of administration. It creates a classic catch-22 situation. You need the money from the estate to pay the tax, but you can't get the money until the tax has been paid. It can be a real nightmare to solve.
Okay, let's imagine you've figured out a way to pay the tax, you've submitted your application, and that official envelope with the letters of administration finally arrives. Huge sigh of relief. But your job isn't quite finished yet. What happens now?
Once you have that legal authority, your role as administrator really breaks down into 3 key duties. First, you have to formally collect all the assets. That means going to the banks, closing the accounts, and moving all the money into a new dedicated estate account. Second, you use that money to pay off any final debts or taxes. And only once all that is done, thirdly, can you distribute what's left to the rightful beneficiaries.
So, who decides who gets what? Well, you don't. When there's no will, you have absolutely no choice in the matter. You are legally bound to follow those strict rules of intestacy to the letter. It's not about what you think is fair or what you think your loved one would have wanted. It is a legal rule book and you must follow it precisely.
So what do these rules actually say? Well, let's take a really common scenario. The person who died was married and had children. In that case, the rules are very clear. The surviving spouse or civil partner automatically gets all the personal possessions. They also get the first £270,000 of the estate's value. Anything left over after that is then split in 2. Half goes to the spouse, and the other half is divided equally between the children.
All right, to finish up, let's talk about the common roadblocks people hit and where you can turn for help. And believe me, paying attention to this part could save you a huge amount of time and heartache.
These are the classic issues that can derail the whole process. Getting the estate valuation wrong, even by a little bit, can cause massive problems with HMRC and lead to months of delays. Simple errors on the forms can get your application rejected. Sadly, family disagreements over who should be in charge are all too common. And as we've already seen, finding the money to pay the inheritance tax bill can stop you in your tracks.
Look, trying to juggle all of this, the legal forms, the tax calculations, the family dynamics, all while you're grieving is a monumental task. It can feel completely overwhelming, and that's why getting professional guidance isn't a luxury. For many, it's the key to getting through it all without making costly mistakes.
This is where a specialist, like an inheritance tax accountant, becomes invaluable.
They can take on the heaviest burdens for you. They'll make sure the valuation is spot on from day one, they can advise you on how to handle the IHT payment, and they will ensure every single piece of paperwork sent to HMRC is perfect first time.
So if you're facing this process and it all feels like a bit too much, or you have other tax questions you need help with, please remember that you really don't have to do it all by yourself.
For professional expert help that's tailored to your specific situation, you can get in touch with the team at My Tax Accountant for a consultation. Their contact details are on the screen now. The phone number is 0208-570-8531, and you can email them at info@mytaxaccountant.co.uk. Just before we end, a very quick but important disclaimer. The information provided in this presentation is for general guidance only. It is not intended to be a substitute for professional advice and should not be relied upon exclusively to make financial decisions.
Before you make any decision or take any action, it's absolutely essential that you consult with the tax experts at My Tax Accountant to get advice that is tailored to your unique circumstances.